Hello, welcome back to my channel. I've got the halo, I've got the angelic halo happening here. How are you? Yes, surprise! I wanted to talk some more about this defamation suit because we've had the if you can remember back to the Tardy Westbrook stuff and what happened when there was service then. Well, we've sort of got the same thing now. Post after post after post after post. So we've got the same thing. Plus, I've done a little bit of research. I should be really doing a contract law assignment. But hey, I just want to also remind you that I'm not a lawyer. I'm a law student and I live in Australia. I come from the land down under. So I don't really know much about the US law exactly. However, it's very, very interesting. Going to put your stream on Twitter. Okay, thank you. So I have pulled up some court rules. I'm going to look at. I am without a lawyer, just for clarification. I know you're without a lawyer. Yeah, so we're going to look at service. I'm really interested in the pocket service stuff that Minnesota has. But definitely very interesting. But I've got some stuff. Hello, Miss Law. I'm not a law graduate. I'm a law student. I miss my lawyer. Okay, so we're going to have a look at some stuff to do with civil action but I found this was really interesting. Remember that we watched the live that stated that she wasn't going to be sued. This is 5 tips when responding to a threat of a defamation. I believe that there was a cease and desist in early March. If you are threatened with a defamation claim or you receive what is known as a Defamation Act concerns notice. Of course, this is Australia, so we actually have a concerns notice. We don't have a cease and desist. But this is relevant for everybody. This is what you should do. Seek legal advice prior to publication. It should always be remembered that in the absence of a viable counterclaim, the best a defendant to a defamation action will ever achieve is to recover some portion of legal costs incurred in defending such a claim. Therefore, if it is intended to publish anything of a controversial nature, which could potentially give rise to a defamation claim, it is always recommended that a suitably qualified lawyer be engaged and to provide pre-publication advice. Seek legal advice after publication. Restrict publication of offending material. If the threat of legal action pertains to a certain published on social media or elsewhere on the internet, then generally speaking, every effort ought to be made to immediately take down or to remove the same. Provide an apology. In Australia, that is one of the remedies for defamation, is an apology, and make an offer to amends. That's the easy option, okay? So limit the posts about the said person. Get some legal advice. Okay. So this is a Minnesota attorney here. So now we're in Minnesota. So it says, what happens when you are served? When you are served, you are given a copy of a complaint or petition and a summons. The complaint or petition explains why you're being sued, and the summons is a document explaining what the complaint means, what is expected of you next, and sometimes when and where a hearing on your case will be. In Minnesota courts, unlike in federal courts, the complaint can be very vague. Minnesota adheres to a standard known as notice pleading, where all is required is a short and plain statement of the claim showing that the pleader is entitled to relief. Federal courts adhere to plausible pleading, where the complaint must contain factual content that will allow the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. If you're being sued upon being served, you are considered a defendant. You are now defending yourself. So this is interesting. So I think it's, so if it's in the general courts, you just have to give a notice pleading. The federal courts, you have to do a plausible pleading. So where they can get the general gist. Now I did, so this is Minnesota court rules explain what steps are necessary to serve a person in Minnesota. Proper service occurs when you are presented with a summons and a complaint for a petition. A police officer or any other persons more than 18 years of age and not a party to the action may make service of a summons or other process. That means that the opposing party in the suit cannot be the person that serves you. However, the court does not serve the papers to the plaintiff. It's up to the plaintiff to serve, make sure that the service. So it's about service. But here is what we've got. We believe that it's this Minnesota HIP service. All right. Minnesota is unique in the flexibility given to plaintiffs regarding the timeline of service. In Minnesota, a person can be served without any document being filed with the court. This is called HIP pocket service and is codified by the Minnesota civil rules. Let's have a look. We're going to pull up this rule because we like court rules. So here we go. What was it? 3.01. Okay. This is interesting. A civil action is commenced against each defendant when the summons is served upon the defendant, when the date of signing a waiver of the service is pursuant to a rule report 4.5, when the summons is delivered for service to the sheriff in the county where the defendant rides person. So essentially, she's been the action has been commenced. Don't it states here that the civil action is commenced when it's served. It doesn't say when it's been Rule 3 filing requirement is set forth in which requires filing with the court within 1 year and day of commencement of non-family cases. Rule 3 is amended to implement the amendment to Rule 405, which replaces the somewhat unreliable procedure involving the acknowledgement of service. And then it says down here. So essentially, here is the rule that it relates to. So that they have, so essentially it's started, okay? And they have it has to be filed in the court 1 year. Filing is set forth in requirement, set forth in Rule 4.4, 5.04, which requires filing with the court within 1 year after commencement. All right. So in Minnesota, a person can be served a complaint and summons signed by the plaintiff's attorney in lieu of the court signature. This complaint and summons will look identical in all other ways and will ask for an answer. While this service tolls the statute of limitations, it gives the parties a year to resolve the case before any document has to be filed within the court. So they're really telling you so you can sort it out between the two of you. Otherwise, if you're still back and forth within the year, it's going to be in court. A defendant on the receiving end of hip pocket service can sometimes be confused because there is no court file number and no signature with the court on the documents. However, like a formal document commencing a lawsuit filed with the court, the hip pocket documents still need to be responded to and is a valid form of service when done correctly. The benefits of hip pocket service are that there are no filing fees to be paid, the court system is not congested by suits that could have been resolved out of court, and the lawsuit is not made public, protecting both the defendant's and plaintiff's privacy. While the defendant is on notice that legal action can be taken, hip pocket service gives the parties an opportunity to resolve the case without filing a document. Because of the very cooperative opportunity that hip pocket service presents, it is often suggested that hip pocket service is a very Minnesota way of resolving a case. So if you're served, you have to, lay out the summons, will lay out your responsibility. In the Minnesota State Court, you must respond to the complaint with an answer. You must respond and answer within 20 to 30 days. An answer is a document that you file with the court that admits or denies every contention made in the complaint. If you do not respond with an answer, you could default judgment. So it says that defendants can file a counterclaim or a document claiming that the plaintiff, in the case whether was a wrongdoer and actually owes the defendant compensation. In some circumstances, a counterclaim must be brought in the current suit or it can never be brought in the future. These are called compulsory counterclaims. A counterclaim is compulsory if it arises out of the transaction that is the subject matter of the opposing party's claim. For example, if person A is suing for damage to their car in a car accident, the person they are suing, person B, must bring a claim against person A for damage to person B's car, claiming person A was at fault, or they are forever barred from bringing this claim. Permissive counterclaims are any claims against an opposing party not arising out of transaction from the subject matter. And again, they're allowed, mandated for judicial economy reasons to save the court time and energy. So really, it looks like a lot of this stuff, that rather than sending them off to mediation, it looks like they are going, you've got to go and do mediation first, and if you can't do it, you've got a year to sort it out. If you don't get it sorted out, then you've got to file it. So I have to give her credit. She's not doubling. She's going hammer and tong. She has no she's going for it. So this was so this is part of the page that was available. Let me have a look here. Where are we? Because they're wanting over $1 million compensation, which is, and I don't know how. Todd's new grape juice. Yes. All right. So here is this is what they want. So, like, for example, in Australia, Christian Porter filed an injunction to have all of his court documents sealed, which he won. So this is part of that. So they want a jury trial on all issues. So they want a jury trial. Request for relief. The plaintiff requests the court grant the following. For a preliminary injunction ordering defendants to make private all posts regarding plaintiffs or their affiliates, and only to allow defendants, plaintiffs, and this court to access the post. Okay? So they want everything that she's posted about them made private immediately. For a preliminary injunction ordering defendants discontinue making any posts regarding defendants or their affiliates. So telling them to shut up. for permanent injunctive relief for defendants to remove all posts regarding plaintiffs, and ordering defendants make no more posts about plaintiffs or their associates. So a permanent injunction. Now, just so that you know, that is what Justice Rares was talking about doing for Google with the Barilaro case. He was talking about making a permanent injunction where Google or YouTube are not allowed to have any posts about Barilaro on YouTube. So they're wanting a permanent ban, so that she or any of her little minions can't talk about them. For judgment in an amount exceeding $1 million to be proven with specificity at trial. So they want over $1 million, and that would be with some formula. All courts have a formula that they work by when a calculation. For judgment in an amount equal to all sums defendants have made from their posts and traffic to their website as a result of their posts regarding plaintiffs. So essentially, they want all the money that she's made. They want all the money that they've made from all the money she's made from them, from all their posts, for all their Instagram, all their Twitter, all their YouTube, and for any further relief as the court seems just and equitable. So that's essentially what they're wanting as relief. They're wanting her to, yeah. It's interesting because civil trials in Australia, very few of them have are particularly defamation trials. We found this out in the Barilaro case, that juries don't tend to get defamation cases in Australia, interestingly enough. Now, I think when we're on to big gigs such as Toyota ATT. Well, and don't forget, she's been encouraging her minions to report, and I'm assuming that they've got all of that. So does that come with data as well? Yeah, it'll be interesting to see what else they want. But I mean, and the other thing was, don't forget, she was on the live the other day talking about how they needed to learn Californian law, and they ended up getting a Minnesota lawyer. So hello. Yeah, that's right. So I did show you some posts. How are you and how was your day? Yeah, good actually. I had my lunch. See, I'm back into my normal comfy clothes. So she says, so Kelly and Dean are to blame for this, not me. I'm confused here because if that's the case, the wrong person is being sued. Also, these kinds of posts will not help in court. So do you want this to end, or do you want to keep defaming me? I've been told that multiple production companies are working on the docuseries on 7M. Does that mean you sue them? What about Lydia, who spoke to The Sun? What about me? What about Rolling Stones, Daily Beast, Daily Mail? Suing me doesn't make this go away. Also, I don't believe that there has been anyone ignoring text messages. Also, I don't believe Miranda wrote this since she's in New Orleans at an event. She is, so it says, thanks to you guys, Mum, Dad, and Melanie, and your involvement with this literally out of control stalker, KJ. Another brand deal of mine was cancelled. I told you that keeping your posts up of KJ shows you're continuing to support her, and you literally ignore me and don't respond to my texts. You guys are just sitting in the background on your butts watching this woman do all your dirty work for you. That's harassing James and now his family. It's disgusting, and you are partners in all this illegal stuff. She does, and it's like you're enjoying this. I do not want to believe this. Your silence speaks louder than you think. And she's hashtag so Miranda, I mean, as I said, one of the things that they've got to prove is that because of the actions of that, they're losing money. And as she's saying, there's a brand deal gone. She says, they call me the Blair Witch Project in this one. Then they tagged literal accounts that stalk and harass me. I cannot. They are suing me. I have full support of my team, which isn't going away. When you fair game, you don't sue knowing that counterclaims are real. What? For the record, they repeatedly reference the lawsuit that I won. The case was dismissed in court. I won when the case was dismissed. The other lawsuits have gone nowhere and will go nowhere. Getting sued is like a badge of honor at this point. No, it's not. You did not win. You settled because you didn't want them to sue you in Minnesota. Oh, come on. You can't. Why can't she just tell the truth? She can't handle the truth. Like him. It says, is she a cult expert, journalist, humanitarian, or a cult victim advocate? Or is she a con artist, a scammer who is out for clickbait and money? Her latest targets are the popular TikTok and IG dancers creators and their management group called 7M. 7M says they are artists and producers have joined forces with top management, who is Katie Joy, an expert manipulator and ruthless persecutor of the church. She is a charismatic leader who's able to garner cult-like following. Many of her conquests, including her rabid followers, whom she turns on and attacks whenever she feels betrayed or opposed. Up until now, nobody has been able to bring her down, despite countless and number of celebrities and victims who have suffered at her hands. Katie Joy is not a regular person. She's obsessed and has a spirit that is unholy. Think Blair Witch Program. They didn't call you the Blair Witch Program. Oh, thank you, Bella. Thank you, Bella. That is very lovely and generous of you. Thank you very much. She says here, they call me the Blair Witch Project in this one. Katie Joy. I think you need to go back and do comprehension. It says, she is not a regular person. She's obsessed and has a spirit that is unholy. Think Blair Witch Project. It doesn't say you are the Blair Witch Project. Like, and it says, warning, she will hurt anybody unless you are spiritually protected. Both her targets and her followers proceed with caution. It doesn't. She was not called the Blair Witch Project. It's a difference. Not 7M. This account is not 7M. I'm pretty sure she named somebody from Twitter runs this account. She's super intense and totally loves me. She's been trolling me for 2 years, so that's not new. But if you can report her post for bullying. Now so she's now telling people to report posts, which I believe is against terms of service. And now we're starting on the trolling. So those of you that have been around for a while, we know the pattern. She's going to now talk about being trolled and being hacked. So this account is my favorite. I don't know what this is. So she's now putting accounts on there. She wants her minions to report. Now, despite reports that Todd Chrisley's criminal case was dismissed, that is 100% false. So because we know that she's got a date coming up with on Zoom for her proceedings with Todd Chrisley. So in the usual projection, despite report Todd Chrisley's criminal trial, so she's written the whole thing there. The government is provided with a without a lawyer, says she has been around for a while and she should know that's not Rhonda. Now, this is, she says, so I am not worried about a lawsuit by Todd related to a police report filed by his daughter, nor am I concerned I defamed him when I reported on police reports, eyewitness accounts, etc. I also spoke to the FBI managing his case, and they were aware of his lawsuit against me. I may be wrong, but I'm pretty sure that even if you were in prison, you can still... Okay, all right. So she's saying that there can be you can't do legal action if you are a criminal. So how do all the criminals get to have their appeals done if they're in jail? It doesn't matter. You're allowed to file civil claims if you're in court. It doesn't matter. But she seems to think that because they're facing criminal charges and she believes that they're going to jail, that the civil case will be dropped. But it doesn't work like that. So she spoke to the FBI agent. I spoke to the FBI managing his case. Todd Chrisley is innocent until proven guilty. I'm being sued. What Dr. Phil aired related to his daughter. He didn't sue Phil, but he sued me. And it's Dr. Phil to you, by the way. So now she's... she makes fun of my crooked chin and calls me a diaper butt. She calls herself the queen of the anti-KJ cult. She's a gem. We should mass report her account so she can say I'm having a massive diaper tantrum. She runs without a crystal balls account and literally needs some serious help. Yes, she is Bella. So yeah. So she's getting the KJ army to do that. So yeah. So I have I'm not sure. So I decided to go in a little bit further because I know what she's going to plead. She's going to plead this is from Minnesota. This is the Reporter's Privilege Compendium. So this is really, really interesting. So who is covered? Well, the Minnesota Free Flow of Information Act refers to news media. It extends protection to any person who is or has been directly engaged in the gathering, procuring, compiling, editing, or publishing of information for the purpose of transmission, dissemination, or publication to the public. All traditional news gatherers are covered by the privilege. Reporter. Courts have applied the privilege to protect reporters, so there's some cases there. Cases involving reporters but denying protection for other reasons. This is what she's going to plead. There's been no specific cases dealing with editors, no specific cases dealing with news personnel. Courts have applied the privilege to photojournalists. Courts have applied privilege to news organisations. Now, she's not a news... So, these courts have applied the privilege to non-traditional news gatherers. The wide-cast net of the Act Shield statute would appear to catch not only reporters and journalists working in traditional news media, but also internet bloggers, unpaid news gatherers, even public relation consultants, as long as they were engaged in any of the enumerated activities, finding the fact, conclusions of law and order. So she could technically be covered. The privilege belongs to the person who is or has been directly engaged in the gathering, procuring, compiling, editing, or publishing of the information. So the statutory privilege is that of the media, not the sources. So this is the interesting thing. Yeah. So what I've discovered is, so what constitutes compliance? Broadcast are not in unpublished order in United States versus Ford, the court quashed the criminal defendant's subpoena against 2 newspapers that sought copies of all articles that appeared in the newspaper over a 3-week period. The court held that the defendant attorney could find all the articles through her own research, and it was improper to shift the burden to the newspaper. So it talks about, look, she could possibly do it, okay, but it looks like that generally Minnesota statute does not extend to published or broadcast materials. In some cases, the published and broadcast status of particular information could be disputed. If so, the court determination that a publication or broadcast has occurred could affect rights of appeal. So we've got defamation actions. So essentially, under this Minnesota law, she could have to cough up if she wants protection under this law, she would have to cough up her sources. So Minnesota expressly provides that the prohibition of disclosure provided in Section 595 shall not apply in any defamation action where the person seeking disclosure can demonstrate that the identity of the source will lead to relevant evidence on the issue of actual malice. Subdivision 2 provides that the identity of the source of information shall not be ordered disclosed unless the following conditions are met: that there is probable cause to believe that the source's information clearly relevant to the information of defamation, and that the information cannot be obtained by any alternate means or remedy less destructive of First Amendment rights. So if she says, well, the devil made me say it, she would have to give up the devil as her source. So this is what I think she's going to try and use, the Shield Law statute. But she's got to be really, really careful because she's, as far as I'm concerned, I don't know that she, I haven't really. Hello, Julie. So, and it's only civil actions in which a court can compel disclosure of confidential or unpublished information that are defamation actions. So, hello, Jan. So it comes down to broadcast, if it's broadcast material, because it may not be covered. So, yeah, no federal court. The statutory privilege does not explicitly distinguish on this basis. This is reporters' personal observations. So, but yeah, they may have to give up. She may. Well, we know that she'll give up her sources if it means that she's going to be spared. But it's. I don't think. I mean, she hasn't really learnt, has she? If I was her lawyer, I'd be telling her to shut up. Look, they'll get her on tortious interference, correct? They'll get her on the fact that she has destroyed their business, I think. As I said, I'm not really great on that stuff, but I would definitely be telling her to shut up. And that would be the nice way to do it. But we know that she's not going to do that either. So let's have a look at. No, well, we forget that she knows more than her lawyers. We know that, don't we? So this is just show you this. This is the Minnesota civil procedure rules. So this is what everything's got to fit under the civil procedure rules. So the form of the summons, personal service. So what happens is you have to Katie. So this tells you, for example, claims of relief, defences, form of denial. So this tells you how. So, for example, general rules of pleading. A pleading which sets forth a claim for relief, whether an original claim, counterclaim, cross-claim, or third-party claim, shall contain a short and plain statement of the claim showing that the pleader is entitled to relief and a demand for judgment for the relief sought. If a recovery of money is demanded, the amount shall be stated. Relief in the alternate or different ways, several different types, may be demanded. If recovery of money for unliquidated damages is demanded in the amount of less than $50,000, the amount shall be stated. If recovery for money of unliquidated damages in the amount greater than $50,000 is demanded, the pleading shall still state merely that the recovery of reasonable damages in an amount greater than $50,000 is sought. So this tells you how you need to plead it. So defences. A party shall state short and plain terms any defences to each claim asserted and shall admit or deny the averments upon which the adverse party relies. So they'll say to plead one, whatever, denied or whatever. If the party is without knowledge or information sufficient to form a belief as to the truth of the averment, the party shall state that this has the effect of a denial. Denials shall fairly meet the substance of the averments denied. A pleader who intends in good faith to deny only part or to qualify an averment shall specify so much as it is true and material and shall deny only the remainder. Unless the pleader intends in good faith to controvert all the averments, the preceding pleading, the pleader may make denials. Yeah. All right. Everybody with me? It means that you'll say that you agree to part of it, but not the other part of it. And then they've got all the amendments in here. So every pleading, written motion, or other document shall be signed by at least one attorney. So sanctions. Remember, didn't somebody say that the lawyers would lose their would be disbarred after this lawsuit, and yet here it is, filed in Minnesota, and and they've got a Minnesota lawyer. Oh dear. Does everybody remember that? Yeah. So anyway, that is how that needs to work out. That's how it all is in Minnesota. So yes, it's obviously that they've got local lawyers, probably working with another, group of lawyers as well. And with their California lawyers. Do you know what would be funny though? Is if they hired Saltsy in California. So I know that some people wanted to have some definitions. So I have got here. Where are we? Secondary sources. There is here a dictionary. Where are we? Welcome to my little treasure trove of all things legal. So this is a link to a law dictionary. So Black's Law Dictionary. And so what we do, so you want to know what the definition of defamation is. So we just put in defamation and we hit search and it comes up to here. What other than that? And then it lists some cases. So it's really good. No, it's not like, so this is, woohoo, adultery, whoa. So we got here defamation. So we're going to go to defamation here, and here is the definition for defamation: a malicious or groundless harm to the reputation or good name of another by making a false statement to a third person. If the alleged defamation involves a matter of public concern, the plaintiff is constitutionally required to prove both the statement's falsity and the defendant's fault. A false written or oral statement that damages another reputation, also libel and slander. And then there's more here. So from the textbook in the law of tort, it's the publication of a statement which tends to lower a person in the estimation of right-thinking members of society generally, which tends to make them shun or avoid the person. So it gives you all these different definitions, and so this one is from the book of this is from the law of defamation. So defamation is involved in two related harms, libel and slander. So now, particularly in Australia, we don't have libel and slander, it's implied. It just comes under defamation. A familiar statement is that libel is written, whereas slander is oral. That covers the idea in general way, but tends to mislead because defamation may be published without the use of words and hence be neither written or oral. Thus, libel may be perpetrated by hanging the person in effigy and slander by sign or gesture. So that's from criminal law from 1982. So defamation per quod is either not apparent but proved by extrinsic evidence showing its injurious meaning, or 2, it is apparent but is not a statement that is actionable per se. So a defamation per se is a statement that is defamatory in and of itself and is not capable of an innocent meaning. And per se also doesn't need to be proven. You don't need to. Yeah, the main problem with the so-called law is how many rental properties are unfit for human. No, yes, correct. So then there's trade defamation, the damaging of business by false statement that tends to diminish the reputation of the business, or it could be called commercial defamation. So anyway, so that is that is the Black Laws Dictionary for defamation. So I can't even spell. I think they will get her on count 3 and 4. They will look. They will get that. They surely will have to get her on a couple of them. And the fact that she has been going presumption of malice. Ooh. The presumption and unprivileged publication of defamation per se was made with ill will and unjustifiable motive. So that's the presumption of malice. So we know that the other thing is that we know she's going around and saying this company is doing this and this company is doing that and we can't support them and this, that, and the other. And the problem that she's got is that by doing that, she's showing that there is malice, intent behind her actions. So, yeah. So, council would put the professional real estate one who's I don't know. Is that a joke? Malice. So let's have a look at malice. I'm falling asleep. Long couple of days. See ya. All right. This is interesting. It says malice, the intent without justification or excuse to commit a wrongful act, reckless disregard of the law or a person's legal rights, also termed abandonment or malignant heart, abandoned heart, ill will, wickedness of heart. This sense is the most typical in non-legal contexts. Malice means in law wrongful intention. It includes any intent which the law deems wrongful and which therefore serves as a ground of liability. Any act done with such intent in language of the law is malicious, and this legal usage has etymology in its favour. The Latin malicia means badness, physical or moral, wickedness in disposition or in conduct, not specifically or exclusively ill will or malevolent. Why do they have all these big words? Hence them including all forms of evil purpose, design, intent, or motive. But intent is of two kinds, either immediate or ulterior. The ulterior intent being commonly distinguished as the motive. So in the legal sense, malice, the absence of all elements of justification, excuse, or recognized mitigation, and the presence of either the actual intent to cause the particular harm which is produced or harm of the same general nature, which is what she's trying to do with, you know, the sponsorships. So there is, you could possibly say that there is malice there, because she had the intent to cause harm. She wants the cult to be brought down. So actual malice in defamation means knowledge by the person who utters or publishes a defamatory statement that a statement is false, or reckless disregard about whether the statement is true. Okay? To recover for defamation, a plaintiff who is a public official or public figure must overcome the defendant's qualified privilege by proving the defendant's actual malice, and for certain other types of claims, the plaintiff must prove actual malice to recover presumed or So they actually have to. So they're saying that KJ knew that her statements are false, was reckless about it, and did it anyway. That's really what part of their defamation thing is saying, that, you know, she's gone and done it even though she knows the false and she's got no regard for the truth. But, you know. Oh, look, I can't speak half of it. It's really quite funny. I can't pronounce half of it. So there's, quite a few allegations in there. So definitely. Being reckless. Da, 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 da. So, you know, Katie Joy talking about the Todd Chrisley seats. This is from Without WOACB Questions. So, all parties, defendants anticipate discovery regarding the parties' respective claims and defences. Discovery should be completed by respect by July 29th, 2022. And expert discovery shall be completed by October 17, 2022. This is the timeline by the court. The parties who have bear the burden of initial expert discoveries reports, August. And then rebuttal is in September. So there's a mediator in June 27, 2022. Pre-trial is in January 13, 2023. The trial starts on February the 4th, 2023. So she's saying that her case is going nowhere. All the dates are being set. For her Todd Chrisley matter. All the dates have been set. Why, if it was going nowhere, why would there be all those dates set? I'm just saying. Why would you have dates set for something that was going nowhere? All right, and then I want to know. What I want to know is her insurance is going to cover her for the lawsuits. I wouldn't have thought so. I would not have thought so. Some people can't. Oh no, they can't let it go. Right. Let it go. Ooh. Must be the end of the world. Well, as I said, she said that she just said here that her other lawsuits aren't going anywhere. She has a whole lot of court dates. No, it will not, because she will have had by now. This I do know because I worked in that industry. Does she win very often? She's never. Oh, she's had one dismissed. She's had one dismissed, one settled. She'll tell you she won, but it was dismissed due to the second one. The Tully Westbrook one was initially. The Tully Westbrook one was initially done because of jurisdiction, but in order to stop them from refiling in Minnesota, she actually settled with her. So, and she gave up her source. And essentially, Tardy got what she needed, and that was who her source was, who was giving her all the information. So, just saying. So does she win very often? Technically, she's had one dismissed due to she's only had one win out of 4 or 5. Is it 5? How many lawsuits is this now? There was the jelly juice, which got dismissed. There was the... What was next? Jelly juice. And then was it Tardy Westbrook, which was settled. It was settled. Dismissed, then settled. Steve McRae. Todd Chrisley. 7M. So apparently that's a badge of honor. I mean, I'd really love now for the Duggars to come in for the kill now. Imagine if they got an injunction. Imagine if the Duggars got an injunction to say that she couldn't report on them. If she was covered, she would be required to hand that case straight to insurance company. If she wanted to claim, they would have had their lawyers made a decision and they would settle, fight, or drop it. Well, that's right. The insurance company, wouldn't the insurance company appoint the lawyers? And I can tell you now, they'd be telling her just to be quiet. And they would most likely settle most of the time because they just want it. No, I'm just saying, Kim, imagine if the Duggars got an injunction. That would be her done. It's fun to fight sometimes. IBAC doesn't want to understand my argument about lawyers, but they can't tell me why the lawyer has been allowed to defraud sin. Well, that's true. Oh, look. They would use their lawyer and not her Walgreens complainer. Well, and see what Google did with the Barilaro matter is that they decided to settle, which I don't understand. I think, in my very limited knowledge, I reckon they could have at least got something, but they decided to just cut their losses and settle. And there's nothing wrong. Sorry, not settle. They're going to have to pay. But they did offer a settlement to Barilaro, but his lawyers talked him out of settling, which I find to be very suspicious. But often settlement is just to get it, dealt with. But I think with Barilaro, they did think it was cheaper to pay him money. I mean, we're still waiting for that decision. I don't know when that decision is going to come. But that, I think, is going to set a precedence too. And particularly if there is an injunction against YouTube about the mere mention of Barilaro's name, because then no one will be able to talk about him on YouTube. So anyway, that's essentially all I got tonight. It's not really a lot, I know. Because I look, I'm not going to be able to get all of them. I'll get the documents if I can, if they become available, but I can't get them in Australia because I don't have an Australian credit, a US credit card, apparently. But yeah, I mean, I'm going to be interested in doing it. I mean, I'll do it as an Australian perspective, I think. So that's all I can do is talk about how, the Barilaro Google one is probably one of the big ones that have happened just recently. So, and that's the last one that I've sat through. So that's the one I'm going to refer to a lot, because I saw it. Look, I might go through and talk about, or have a speaking to us. So Barilaro will want to clear his name. I think though, ICAC might have something to do with that. Here's my thing: what happens if ICAC then proves all the allegations? Let's just say that what Friendly Geordies wrote with some of the allegations about Barilaro, if it turns out that they're correct, can then Google take him to court to get their money back? I don't think you can, but it would be interesting to see if that was the case. But yeah. But as I said, it'll be very interesting. But look, I'm going to head off now because I've got an assignment to do. I've got to do an assignment. So, I got mentioned in Bill's, Crystal Bill's I got mentioned in Crystal Bill. Do we discuss the prayer room? Shall we want to have a quick discussion about the prayer room? I tell you what, I don't ever want to go into, if I ever have to go to Parliament House and I'm going to be offered a tour of the prayer room, I'm going to say no thank you. The prayer room, it's interesting again. This is it's something that mainstream media is not really talking about. Now, I went onto the Friendly Geordies. I wanted to show you something. I searched up prayer room. I'll just briefly touch on it, but I want to do a please do not be PP. I'm going to. You're gonna need you're gonna need lots of sanitizer after. So this is I'll put the link in here. This is it's funny how this is all kept quiet. So leaked documents reveal investigations. Friendly Geordie's team have been provided with documentation that detail investigations into what happened, specifically in the prayer room. So they've got the links, and I'm not going to read it out, but I've got the link there. You can click on it yourself. But see, it says that the mainstream media said that they couldn't substantiate their claims about the use of rent boys, and said that no one had signed in. A search of parliamentary sign-in records found no evidence that a sex worker was ever signed into the building. Do they really think someone's going to sign in as a sex worker? And they've actually got the full report here, which is what I want to look at, which has been redacted, of course. We have a prayer room at work today. We an online booking system. I'm glad I'm the cleaner, hey? Yeah. So this is what I want to know is why the Victorian Liberal Party has been very quiet on this too. But it's all here with all the bits redacted. You book it. Is it Peter? Is it one person at a time? As a taxpayer, I'm absolutely disgusted that this is going on, and that it's just been swept under the carpet. They didn't even show half of this. I'm just scrolling through this and I'm going, no, wait, filming. They've got screenshots. I mean, they've got evidence. Screenshot of message, including the 3 videos. There were 3 videos. So here is the full, oh, wow. And yet, it's interesting. So that's the report that names them all. And nothing's been done about it. So there's their sources. So anyway, and then that's Tom the whistleblower. He's the one that started it. Well, remember he had the Australian Federal Police raid him because he whistleblowed on them. I can't believe that. Don't care how many go in, but you're responsible for the time in there, and you wonder how Tom the whistleblower had the evidence. Yeah, I don't know. But it's shocking. But yeah, I want to look at that in more detail a little bit later. Once we can get I was going to say once KJ calms down, but I don't think she's going to calm down. I think she's going to give us some content for a little while. But anyway, on that note, I've got to head off because I've got assignments to do. I've got 4 assignments to do before next Thursday. I fly to Adelaide, fly to South Australia next Thursday for choir for Easter on an Easter tour. And I have to have all my assignments done before Easter, and I've got 4 of them to do. And how many have I started? I've still got notes. I've taken notes. I've just now got to get my notes from my books and just put them into some type of logical order now. So anyway, all right, well, thank you for watching, and I will catch you again next time. Bye for now.